Mr. Domina, good morning.
May it please the Court, I'm Dave Domina. I'm here on behalf of Rex Moats. Your Honor, since Nebraska became a state, the First Amendment has stood for one proposition. Speech is free as long as speech is true. In this case, Rex Moats declared himself as a candidate for the nonpartisan Nebraska legislature, and he was faced with a series of publications described in the pleadings, publications by the Republican Party. Those publications repeatedly say that Mr. Moats signed and filed in a court a false affidavit. They accuse him of a crime. 4 of them do. They also accuse him of taking $50,000 in trust money from an insurance company that had failed and couldn't pay its policyholders. The truth of the matter is that Mr. Moats blew the whistle on the insurance company. His activity led to its receivership. He was the first employee of that insurance company engaged by the receiver, KPMG, with a court order, and he was the last employee to leave that receivership. He served it throughout its entire course as it liquidated to protect policyholders. Mr. Moats offered himself for public service. He ran a nonpartisan campaign for a nonpartisan office, an office that was conceived by a Nebraskan, George Norris, who understood that the purpose of a nonpartisan legislature was to keep national party politics out of the process. Our legislature still proudly proclaims that on its website and its homepage. Well, that's not the way it worked. These publications each bear the name, the mailing stamp, and the number of the publication of a major Nebraska political party, the party we've sued. That party conceived and designed these products to influence an election. That's the business the political party is in. Its purpose, its function, its organization, its reason for collecting money, hiring staff, paying payroll, sponsoring conventions, having a business manager is to engage in the business of politics. Mr. Moats believes he has a remedy under Section 59-1602 as a result. He believes that the major political parties of this state, including the one he sued here, engage in trade or commerce. And that trade or commerce obviously affects Nebraskans. In this instance, it affected Nebraskans as they exercised their franchise to vote and made an effort to select a constitutional officer. And in that process, they were misled because the political party that is the defendant here engaged in deception. The statute forbids deception. It uses the word deception. It engaged in a false practice, which is forbidden by the statute. Now, the party says it doesn't engage in trade or commerce. Your sister courts, most recently Michigan, have observed that the political process, including the activity of political parties, involves the expenditure of billions of dollars. In our state, about 35,000 people are represented by each state senator, one of 49. Our campaigns routinely cost here $300,000 or $400,000 per candidate now because of expenditures for products exactly like this. Mr. Moats lost the election. No problem. No problem. That's not the complaint. It's not about the outcome. He didn't make any attempt to intervene before the election was over and the people had spoken. He's here because he was lied about, because he wants an opportunity to prove that to a jury and to vindicate himself. He did not sign or give a false affidavit.
When you opened your remarks with the reference to the false affidavit, and how many publications do you believe that appears in?
It appears in 4, Your Honor. It appears in publications 2, 3, 4, and 6. 6, for example, Mr. Moats claimed in an affidavit that national warranty was doing financially well.
I have that in publication 3.
That's also in publication 3, Your Honor. I think exactly the same language. I happen to be reading from 6.
All right.
I think you're right. Publication 4 is the one that we put in its entirety in our complaint, cut and pasted a picture of it. That's the one that purports to be a letter from Mr. Moats in which he talks about his affidavit.
Are these things you allege are defamation per se? Is that
Those are, Your Honor. Those accuse him of committing a
so?
crime.
Which publications would those be?
2, 3, 4, and 6 mention the
The
affidavit.
appellee in the brief argues that these publications are not actionable because they're either opinion, satire, or hyperbole. What's your response to that?
Mr. Moats, you signed a false affidavit. That is not satire.
So that's where you're focusing, is on the false affidavit?
That's the easy part, Your Honor. Those we should prevail on for sure. Those, I think, are the simplest for the court. The harder part are the other publications. And as you know from our complaint and our brief, one of the publications, number 10, we selected to put in the complaint and acknowledge that it's not defamatory, and said that it's actionable under our other theories. So our purpose for that, frankly, was to get a pleading before the court below, and now you, that raises the unfair competition issue. We think on defamation we win. We're entitled to reversal clearly. We cite some cases from Connecticut, North Carolina, where there have been similar holdings. We don't know of one that involves the unfair competition provision of Section 59-1602 or its analogous provision in other states.
What's your response to Appellee's comments with respect to either that appellant did or did not seek leave to replead and so forth?
Well, number one, the rule says that we can request leave at any time. As the court knows, there is no record of proceedings below. As far as the court knows, there wasn't even a hearing held. The court just ruled on the motion. So we seek leave now, since we can do that at any stage. Number two, at the time this case was decided, the governing precedent, I think, was from the Court of Appeals in Bailey versus First National Bank of Chadron, which holds that a trial court must announce a reason why it does not automatically grant leave to dismiss if it dismisses without leave.
But did the case go more to abuse of discretion rather than requiring a ruling on
You mean,
amending?
is your question about Bailey, Your Honor?
Yeah.
As I recall, Bailey, what happened was that there was no question about a request for leave. The trial court simply dismissed without announcing any reason why or suggesting whether it would or would not entertain leave.
I beg your pardon, but in this case then, is this correct that the first time request to amend is being made at the appellate level?
It may be, but it's also clear from the record that this is our first opportunity to request leave. We got an order dismissing. Were we supposed to anticipate dismissal?
I suppose you could file a motion for reconsideration and ask leave to amend. Couldn't you do that at the trial level?
We could have, Your Honor, but you know our practice doesn't include a motion for reconsideration. I know they're commonly used, but we don't have a rule that authorizes them. I'd like to.
It never stopped a lot of other people.
I understand it hasn't, but maybe it should. That's why we have rules. Thank you.
Thank you.